Good morning. In this part, I will focus on the CDD and record-keeping requirements and other statutory AML CTF requirements. As we have gone through the major AML CTF requirements in our seminar last year, this year I would like to refresh your memory and remind you of the basic requirements as they are very important, and I will also draw your attention to some points to note when applying the requirements, and also some areas or examples of common problems that we noted over the past 2 years of implementation. As you should know, a TCSP licensee, when by way of business in Hong Kong, prepares for or carries out for a client a transaction concerning a trust or company service, it has to comply with Schedule 2 to the AML, which contains the CDD and record-keeping requirements. The CDD measures under Section 2 of Schedule 2 are set out in this slide, as you can see. They are basic but fundamental and very important, so I still need to mention them, especially the first one, identifying the customer and verifying the customer's identity. And also, if there is a beneficial owner, a BO, in relation to the customer, licensees are required to identify and take reasonable measures to verify the beneficial owner's identity, and also obtain information on the purpose and intended nature of the business relationship established with the TCSP licensee, unless the purpose and intended nature are obvious. And in case where a person purports to act on behalf of the customer, licensees have to identify that person and take reasonable measures to verify the person's identity, as well as to verify the person's authority to act on behalf of customer. One example is where a director, for example, a director of your customer, which is a corporation, approaching you to say, engage you to prepare for the annual return for the corporation, then in that case, you should identify the director's identity, and also request, and also take reasonable measures to verify the director's identity, as well as verify the director's authority to act on behalf of the customer. So, for example, to request for the written authorization or the board resolution, etc. And from time to time, we actually have received some questions asking, like in practice, how we should carry out these CDD measures, and what documents should we obtain? Can CR list out the documents that we need to prepare? Things, questions like that. And actually, the answer is actually in our AML guidelines. You can look at Chapter 5 of our AML guidelines for further details. And in particular, please look at the appendices of our guideline, which provides guidance for the identification and verification of different types of customers and their beneficial owners. So basically, first, you need to see which type of customers you are dealing with, whether your customer is an individual, a corporation, a partnership, or a trust. Then you should check whether the information and documents respectively required in Appendix A, B, C, and D of our guidelines have been obtained. Say, for example, if your customer is a corporation, then you should go through the information required under Appendix B. In some cases, we actually note that some licensees focus on the director only instead of the corporation itself, and they only provide us with the ID card copy of the director of the corporation. However, as the customer of the licensee is actually the corporation itself, the licensee should identify and verify the corporation instead of just the director. So although the licensee is also required to independently identify and verify the names of the directors and shareholders recorded in the company's registry, they still need to obtain other information and documents in relation to the corporation itself, such as a copy of the certificate of incorporation, a copy of the business registration certificate, and articles of associations, details of the ownership and control structure of the company, for example, an ownership chart, and also a list showing all the directors of the corporation. So the next question is, when do TCSP licensees need to carry out CDDs? The TCSP licensees must know when they should carry out CDDs, as set out in this slide. The common situations that under which they need to carry out CDDs are before establishing a business relationship with the customer, and also when the licensee suspects that the customer is involved in money laundering or terrorist financing, then you also need to do the CDD. The requirements under Section 3 of Schedule 2, if these are not complied with, then the licensee must not establish a business relationship or carry out an occasional transaction with that customer. We have also come across some questions like asking whether the licensee needs to conduct CDD on an existing customer, so-called the old customer, whether they need to conduct CDD on them. Actually, apart from carrying out CDD on new customers, in situations set out in Section 6 of Schedule 2, as you can see in this slide, the TCSP licensees are required to carry out CDD on pre-existing customers as well. So what is pre-existing customers? Pre-existing customers are those with whom the business relationship with the licensee was established before the anti-money laundering and counter-terrorist financing financial institutions amendment ordinance came into effect on the 1st of March 2019. So if you form the business relationship with the customer before that date, then they are pre-existing customers, and you need to conduct CDD when upon the happening of some events or in the situation set out in Section 6 of Schedule 2. The situations include, among others, where a transaction which are unusual or suspicious, and when the TCSP licensee suspects that the customer is involved in money laundering or terrorist financing. If the licensee is unable to carry out CDD in such situations, then the business relationship with the customer must be terminated as soon as reasonably practicable. So the very first thing you need to consider is whether the customer is a new customer or a pre-existing customer. For example, you may check since when you acted as the company secretary for your customer. As you need to conduct CDD on new customer in all cases before the business relationship is established. While for pre-existing customers, you should watch out for the triggering events and conduct CDD in those situations. But whether your customer is a new customer or pre-existing customers, TCSP licensee in both cases also need to continue to monitor the business relationship with the customer by reviewing from time to time documents, data, and information relating to the customer to make sure that they are up to date and relevant, and also scrutinize the transactions carried out for the customer to ensure that they are consistent with your knowledge of the customer, and also identify transactions that are complex, unusually large in amount or of an unusual pattern, and those which have no apparent economic or lawful purpose. You also need to examine the background and purposes of those transactions and set out the findings in writing. As mentioned in the seminar last year, in certain situations, TCSP licensees are required to take additional measures as EDD, the Enhanced Customer Due Diligence, in addition to the CDD requirements. High-risk situations for which EDD apply includes situations where the customer is not physically present for identification purpose. That is the non-face-to-face situation. And also where the customer or the beneficial owner of the customer is a politically exposed person. And the definition of, because we have been asked about the definitions of PEP, the politically exposed person in the webinar in the past 2 days. So actually you may look at Section 1 of Schedule 2 of the AML, which provides the definition of PEP. And the first situation, the first high-risk situations in which EDD has to apply is when in any situation specified by the registrar in a notice given to the licensee, and in any situation that by its nature may present a high risk of money laundering or terrorist financing. For instance, where the customer is from a jurisdiction that does not adopt or insufficiently adopts the FATF recommendations. Certain additional measures have to be taken in each situation, such as obtaining approval from its senior management to establish or continue the business relationship, and taking reasonable measures to establish the customer's or beneficial owner's source of wealth and the source of funds. I'm not going to go through the measures in detail here. For the additional measures in each situation, please look at Sections 9, 10, and 15 of Schedule 2 to the AML. But I do want to talk a bit more about PEP because of the deficiencies, of some deficiencies noted during our compliance inspection and interviews. For PEP, when TCSP licensees know that a customer or its beneficial owner is a PEP, they should, before establishing a business relationship or continuing an existing business relationship where the customer or the beneficial owner is subsequently found to be a PEP, the licensees have to carry out EDD measures under Section 10 of Schedule 2. Apart from that, actually Section 19, Subsection 1 requires that a TCSP licensee must establish and maintain effective procedures for determining whether a customer or a beneficial owner of a customer is a PEP. These two requirements are different, and sometimes they're overlooked. Section 19, Subsection 1 is as regards determining whether a customer or its beneficial owner is a PEP. And in case it is, then EDD has to be applied under Section 10 of Schedule 2. It is in fact also a requirement under our AML guidelines that TCSP licensees must establish and maintain effective procedures, for example, by making reference to publicly available information and screening against commercially available databases in order to determine whether a customer or beneficial owner of a customer is a PEP. And other important parts of Schedule 2 is that a TCSP licensee must comply with the record-keeping requirements in relation to each transaction and each customer. For each transaction, the licensee has to keep the original or a copy of the documents and a record of the data and information obtained for at least 5 years from the date on which the transaction is completed. Whereas for each customer, the original or a copy of CDD information, customer files, and business correspondence with the customers must be kept throughout the business relationship with the customer and for at least 5 years from which the date on which the business relationship ends. Actually, you may also wish to note that the records can be kept in a computer database, because we have been asked about whether the records can be kept in electronic form. So would like to point out this. Another point to note is that there's quite a common problem that staff trainings records are not kept. So I would like to remind you of the requirements in our AML guidelines that TCSP licensees should maintain staff's training records, including the date and type of training received by each staff for a minimum of 3 years, and be made available to our inspection officers if our officers ask for it during our compliance inspection or in other occasions. Actually, there are also other requirements under the AML to which I would also like to take the chance to draw your attention. One is Section 19, Subsection 3 of Schedule 2, under which the licensee must, in respect of each kind of customer, business relationship and transaction, establish and maintain effective procedures for conducting CDD and EDD. And also there is a general requirement that under Section 23 of Schedule 2 that TCSP licensee must take all reasonable measures to ensure that proper safeguards exist to prevent a breach of Schedule 2 and to mitigate money laundering and terrorist financing risks. On this, I would like to mention some important requirements in the guidelines that may help you to implement these two general requirements. Because actually our guidelines is important because in considering whether a person has breached Schedule 2, we will have regard to the requirements in the guideline as well. Under our guideline, it is explicitly stated that TCSP licensees must assess the ML or TS risks of their businesses, develop and implement procedures, policies, and controls, which we call AML CTF systems. And TCSP licensees should establish and implement adequate and appropriate AML CTF systems, taking into account factors including the services offered, the type of customers, the geographical locations involved. And also the senior management of any TCSP licensee should appoint a director or senior manager as a compliance officer who has the overall responsibility for the establishment and maintenance of the licensee's AML CTF systems. And also, a senior member of the licensee's staff should be appointed as the money laundering reporting officers, who is the central reference point for reporting suspicious transactions. Also, as when you may be aware that it is the conditions of license that the licensee should appoint a compliance officer and a money laundering reporting officer during the term of the license. And also the licensee should put in place adequate and proper AML CTF policies, procedures, and controls as evidenced by the policy statements or other written documents. So make sure that you have a policy statement, and in case we ask for it, it should be readily available. Because disciplinary action may be taken if the license condition is not complied with. In addition to the requirements in Schedule 2, our AML guidelines also contains other statutory requirements that are concerned with money laundering and terrorist financing. As we have talked about them last year, in the following part, I will focus on some key points to note. First of all, let me talk about financial sanctions and terrorist financing. Please note that the relevant legal requirements do not only apply to licensees, but also apply to every person. Please don't mix up sanction destinations and tariffs with PEP, to which EDD under the AML applies. It is prohibited by the relevant regulations under the United Nations Sanction Ordinance to make available or deal with economic assets directly or indirectly to individuals or entities designated by the UN Security Council, as well as individuals or entities acting on behalf of or at the direction of or owned or controlled by designated persons, individuals, and entities. The term economic assets means any funds or other financial assets or economic resources. TCSP licensees should not establish business relationship or conduct transactions with any individuals or entity subject to financial sanctions. A person who contravenes the above prohibitions is liable to an unlimited amount of fine and imprisonment for 7 years. In relation to TF, the relevant legislation is the United Nations Anti-Terrorism Measures Ordinance, which, among other things, criminalizes the provision or collection of property and making any property or financial or related services available to terrorists or terrorist associates. Please be reminded that not to have any business relationship with any relevant person or entity which is subject to financial sanctions or any terrorist or terrorist associate. You may look at our Chapter 8 of our AML Guidelines for more details. As some deficiencies in these areas have been noted during our compliance inspection, I would like to take the chance to highlight some relevant requirements under our AML guidelines, which sometimes have been overlooked. All TCSP licensees will need to ensure that they should have an appropriate system to conduct name checks against the relevant list for screening purposes, and that the list is up to date. Licensees should also ensure that it maintains a database of terrorist and sanctioned destinations. And licensees should also pay close attention to the latest list of individuals and entities designated, as they are required to conduct name checks. And entities and individuals acting on behalf of or at the direction of or owned or controlled by those on the sanction list should also be covered. In order to demonstrate compliance with the requirements for screening of customers, the screening and any results should be documented or recorded electronically. The most up-to-date list of sanctioned persons and entities are available at the website of the CR's Trust and Company Service Providers Licensing Regime, as well as the website of the Commerce and Economic Development Bureau. In relation to PF, that is the financing of proliferation of weapons of mass destruction, at the UN level, to combat financing of proliferation of weapons of mass destruction, the United Nations Security Council has implemented sanctions against 2 countries, namely the Democratic People's Republic of Korea and Iran, including targeted financial sanctions against designated individuals and entities. Such targeted financial sanctions are implemented in Hong Kong by 2 regulations under the United Nations Sanction Ordinance. That is, the United Nations Sanctions Democratic People's Republic of Korea Regulation, which is specific to the North Korea, and the United Nations Sanctions Joint Comprehensive Plan of Action Iran Regulation, which is specific to Iran. Activities, transactions, or relationships that are suspected to be related to weapons of mass destruction proliferators should be handled with great caution, as under which it is an offense, as it is an offense under the Weapons of Mass Destruction Control of Provisions of Services Ordinance, to provide any service to another person where he believes that or suspects on reasonable grounds that those services may be connected to PF, including, for example, the lending of money or other provision of financial assistance. The final part of my presentation is reporting suspicious transactions. As Mr. Yip of JFIU will cover this part, I will just quickly go through the relevant legislations. The first one is the Drug Trafficking Recovery of Process Ordinance, and also the Organized and Serious Crimes Ordinance. The third one is the United Nations Anti-Terrorism Measures Ordinance. Under these ordinances, it is an offense if a person fails to disclose his knowledge or suspicion of any property that represents a person's process of drug trafficking, an indictable offense, or property which is terrorist property. This offense carries a maximum term of imprisonment of 3 years and a fine of 50,000 Hong Kong dollars upon conviction. Last but not least, may I remind you again that licensees should, in cases of suspicions of money laundering, TF, PF, or sanction violations, you should make a report to the Joint Financial Intelligence Unit, which is jointly operated by the Hong Kong Police Force and the Hong Kong's Customs and Excise Department. But we would also like to remind you of some requirements to report suspicious transactions under our guidelines. On this, licensees are advised to familiarize themselves with the safe approach promoted by JFIU. Mr. Yip will talk more about it in his part. And also, under our AML guidelines, TCSP licensee should have measures in place to check that it has proper policies and procedures to test and ensure compliance with legal and regulatory requirements. And also, as we have come across some problems that we noted during our compliance inspection, I would like to take the chance to remind you that TCSP licensee must establish and maintain a record of all MLTF reports made to the MLRO, and the record should also include details of the dates when the report was made, and also keep a record of all STRs made to the JFIU. The record must include details of the dates of the disclosure, the person who made the disclosure, etc. This is the end of my presentation. May I now pass the stage to Mr. Yip of JFIU. Thank you.